DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on constitution. Now, Lord, 370 is perhaps the most brilliant, Lord, articulation of statesmanship on the part of the constitutional framers. You are at a time when the Lord calls for plebiscite in Kashmir are being raised. You are at a time when raiders are raiding the Lord in plain clothes and trying to take away. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India or Pakistan. You are at a time when Lord India is just being born as a Lord dominion nation. At a time like that, Lord, it was a brilliant compromise that was arrived at, which Lord led to Lord producing this article, which persuaded the people of Jammu and Kashmir to accede to India. We gave them a promise. You cannot Lord breach that promise in the manner that you have done, or for that matter, at any point of time. And that's why, Lord, what Dr. Dhawan very rightly points out, that Lord, ultimately, each Lord, article of the Constitution, Lord, deals with this kind of diversity, which, Lord, if we were to start tinkering with, then, Lord, nothing will be left of the Constitution. So, Lord, your Lordships may have to consider, Lord, and my respectful submission, three, Lord, submissions. One, that Article 370 is a piece of, Lord, unusual, Lord, draftsmanship. It is temporary, but it is not temporary by a flux of time as most temporary statutes are. It is temporary by object, the purpose. Once that object is achieved, once that purpose is subserved, then, Lord, nothing remains for the president to exercise. So, Lord, it's going to be my respectful submission that 373, Lord, has served its purpose. The day Constituent Assembly of Jammu and Kashmir agreed that yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted and issued that modification in Lord CO 44. That's the end of the story. Lord, your Lordships have taken the view right from federal court, and I will show Lord series of judgment that temporary statutes, Lord, General Clauses Act does not apply. If that is so, then Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be exercised again and again. Now, if it is not a continuing exercise on a demurrer, in my respectful submission, then Lord, the only way Parliament could do it is by amending the Constitution under Article 368 and repealing Article 370, and in no other manner. And I will show, Lord, that's the view, Lord, 8 of your Lordships have taken in Berubari's case, where your Lordships, Lord, interpreted a treaty and said that you cannot do this unless you amend the Constitution. And lastly, it's going to be my respectful submission for your Lordship's kind acceptance that the exercise of powers by the President on 5th of August and 6th of August 2019, Lord, are nothing but fraud on the Constitution. As Dr. Dhawan rightly points out, there is nothing on record why a provision which has successfully survived from 25th October 1947 till Lord 6th of August 2019 should have been Lord repealed, as they claim, or should have been withdrawn. There was no material whatsoever. The only material with respects was that the ruling party in its manifesto in 2019 had said, we will abrogate Article 370. Your lordships in DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on constitution. So, Lord, you have a government in association with a local party in Jammu and Kashmir. It is working well. You suddenly withdraw the support from that government. Then you persuade the governor to issue president to issue a 356 order. Then you persuade president to issue a resolution of the assembly. Parliament then apparently takes control of legislative and executive functions, and then you say, now president will exercise all powers into one and pass orders under 370. What more classic example of abuse of power than this can be? As Chief Justice Coke said, way back when the fight began with the king, that king can do everything except making a man a woman and a woman a man. Surely president could not have exercised these powers under 373, assuming himself to be everything. Has been pointed out at great pains and very brilliantly, that 356 is a temporary provision. Now, 356 being a temporary situation, can you take actions which are permanent or permanency or permanent in nature? Forget anything else. Because 356 itself says that everything that you have done in the interregnum will come to an end. And maximum period for which you can exercise 356 is 3 years. So, to do this, in my respectful submission, it really strikes at the very basic features of our constitution. Democracy, federalism, Government of India in their affidavit before your lordships categorically admits this, and this is very important, the counter, which I'll read at appropriate stage, that Constituent Assembly of J&K did not in any manner deviate from the provisions of the Constitution of India, which would be applicable to J&K. This is their profound statement. Then they try and they say that ultimately that what we have done is because of national interests. Nobody knows what this national interest is because it's not been defined in their counter affidavit. There was no material whatsoever. As I said, it has survived. Of course, there is insurgency. Nobody can deny that. But then we have insurgency in so many states in Northeast India. We had insurgency in Punjab for a long time. If we were to start disintegrating states into union territories in this manner, no state will be safe in this under political class that we have today. Tomorrow it may so happen that my party cannot get elected in a state. I will disintegrate into union territories because there is law and order problem. this is something which your lordships will have to very seriously consider. It's not just one-time exercise. It has such broad ramifications for future of India, for the constitution of India, for federalism, for very existence. That it will really be giving now this kind of a power to a majoritarian government will be destructive of rule of law. It would be terribly destructive of rule of law. And I beseech your lordships, that's why in Coelho, your lordships have very beautifully put it, that constitutionalism demands that your lordship should oversee every act of the parliament and the executive. And the moment your lordships will find that there is infraction of constitution, your lordships will come down heavily on them. It's all right to create this atmosphere of fear all around. Nobody, one thing I must tell your lordships, very interesting, very few people, way back on 27th May 1949 in the Constituent Assembly, a debate was going on about bringing 4 representatives of J&K who had not been invited so far. Question was whether they should be nominated or not, because everybody felt that they should be present. So Mr. K.T. Shah, who was an advisor to government of Jammu and Kashmir and who had Professor K.T. Shah had worked there very extensively, he made this statement which was very interesting, which was perhaps quite inappropriate. He said, it has been the declaration of highest authority of India and also that of accession of the state made by the Maharaja, who was the complete constitutional head on the day that accession was agreed to, was subject to confirmation by result of plebiscite. Now please see Pandit Jawaharlal Nehru's retort to that. Jawaharlal Nehru retorts by saying this is absolutely incorrect, 100% incorrect. I am amazed, surprised and astounded that such a statement is made by Professor Shah. Why? Because Kashmir had certainly become part of India and it will always be a part of India. Nobody denies that. Article Section 3 of the Jammu and Kashmir Constitution itself provides that we are part and parcel of India. Question is that when you have now, as your lordships have very rightly questioned about sovereignty, you can acquire a new land by either accession or by cession or by occupation. In each of these cases, you can take away complete sovereignty, as my Lord the Chief Justice observed. But what happens in a situation like this, where you have agreed as a nation, as a dominion, as a state taking over that territory, that I take your territory subject to this condition. What happens then? There, Derubani says that you cannot now get out of those conditions. And the only way you can do it is by amending the Constitution of India. Now, you don't want to amend the Constitution of India because then you have to follow the procedure. You need 2/3 majority in both houses. You may even need to go to the legislatures of the state because you are taking away representation of the state in Lok Sabha and Rajya Sabha. So you will need 50% of the states to agree to that provision. So these are the safeguards. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So it is very therefore important for us to understand that this is not just about Jammu and Kashmir, Jammu and part of India, but the promise that India made to Jammu and Kashmir, the cession which came about on terms and conditions. How do you interpret those terms and conditions? So your lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your lordships that Premnath, first, your lordship said that yes, we have to await the confirmation by the Constituent Assembly. I will show those passages. Then in Sampat Kumar, your lordship said, Constituent Assembly has given that assent. People have agreed to abide by this. And President has accepted. So both ways your lordship's court in these two judgments give a complete finality to what is the eventuality under Article 370, sub-Article 3. So, Lord, in my respectful submission, this calls for a very different kind of a approach than what government of India would like your lordships to take. Lord, that's an extremely, I would say it's a narrower approach. That's not how constitutions are interpreted, Lord. They have to be, these are durable provisions. They must go through the test of times. If merely because something has happened or is happening in Jammu and Kashmir, you have to do this, then it may happen in another state and you might be called upon to do that again. So, the power cannot be exercised because of certain situation prevailing at a particular point of time. Constitutional provisions can't be tinkered within that fashion. So, how do you make them durable? You make them durable by really understanding. But the need of the hour was that we wanted Kashmir to get into us, Jammu and Kashmir. So, at that point of time, we were left with no option but to accept what they offered us. Otherwise, we were afraid Maharaja might run away to. There was one fear that he might go to Pakistan. He might join Pakistan. So, nobody knows what exactly was happening, but who were the people who really were aware? The constitutional framers. And Dr. Iyengar's exposition of 370 is really the complete answer. Although I am conscious that Constituent Assembly debates may or may not be relied upon, but it gives a complete answer to what government tells us on Note 370. He also says that all that we need is the wishes of the people expressed through a Constituent Assembly. Once that wish is expressed, it's the end of the matter. He says that, and I'll read that two paragraphs of this. So, whichever way one looks at this provision, in my respectful submission, this controversy needs a very, very delicate approach from your lordships, so that we do not end up creating a situation. Today, let us assume for the sake of argument that today this decision is in national interest. Let us assume for the sake of argument. Tomorrow, some other political party in power with majority may try and take a decision which is not in national interest. You have to therefore lay down law which will stop all these exercises for all times to come. And that's where constitutionalism comes into play. And I beseech your lordships with all humility at my command that your lordships may therefore look at it this way. Now take therefore in this regard, kindly turn straight away to one judgment of your I have a compilation of judgments which are new, but you can also, Prasanna, you can add them. We can. It is already with Prasanna. I can add them with just in 1 second if your lordships permit.
It is part of the existing compilation now.
It's not with your lordships, it's with the Learned Courtmaster, volume 30. 130, case law. 130. Case law compilation.
So what is volume 29? We stop at volume 28.
29 and 30 have not been allowed by the lordships. These are judgments only.